Ladies and gentlemen, I welcome you to the NISSMAT podcast on intellectual property rights. Today we unravel the complexities of counterfeiting and brand infringements. I'm your host, Pavanji Taluwalia, moderator of NISSMAT. NISSMAT stands for the National Institute of Security, Safety, Management and Applied Technology. NISSMAT has four wings: the Forum, Academy, Enterprise, and the Foundation. May I request you all to like, share, and subscribe our channel so that whenever we make a podcast, you receive it immediately. Today, I have a very distinguished personality with me to discuss this subject, Mr. Sipal Singh. Mr. Sipal Singh is a former police officer who's held various senior appointments in the government of India in various parts of the country. After retirement, he was instrumental in running an organization called the Brand Protection Associates, which was deeply involved in protecting brands from erosion. Therefore, he is the most apt person to talk on the subject. Mr. Sipal Singh is also the president of NISSMAT, and today he will talk about what are the laws that govern the intellectual property rights. I begin by asking Mr. Sipal Singh the first question. How do you define intellectual property rights, and what are the important enactments in India on this subject?
Thanks a lot, Mr. Pavanji Aluwalia, for introducing me in a such high manner. Yes, indeed, I have an experience as far as the intellectual property rights are concerned, particularly with reference to the copyrights and the trademark merchandise, which are very often used by the enforcing agencies and the enforcing groups to counter the movements, to counter the criminal intentions of the counterfeiters. So with this one, I want to go to the question. Your first question is intellectual property right. Actually, intellectual property right is invariably of tangible nature. In each case, it consists of a number of rights. For example, in the case of patents, the property rights relate to exclusive right to use the invention patented. Whatever inventions are patented, its exclusive right to use comes under the intellectual property right. It means holders of the intellectual property right has a monopoly on the usage of property or items for a specific time period as registered. India has a number of legislation on this. I'll only refer to a few important intellectual property right legislation. First, I have already mentioned about patent right. This Patent Act was introduced in 1970. The invention under patent law can be absolutely a new product. It can be absolutely a new product, or can be an improvement of some existing product. The patented product can be an absolutely new product, or it can be an improvement of some existing products and then patented, or can be absolutely a new process of manufacturing. But the product may be existing already, but new process is involved. So this process is patented along with the product itself. So in this case, the Patent Rights Act is one which is very important from the point of view of the people who have some patented rights. Then we have the Design Act. Design Act is 1911. It was enacted and then amended in 2000. Under this act, the registration is for a period of about 15 years, subject to renewal as prescribed under the rules. There are laws governing industrial designs under the Design Act 1911. Then you come to the Geographical Indication of Goods Act. There are another IPR, Intellectual Property Right Act. In this act, the geographical indication is defined as an indication used to identify the goods, whether natural or manufactured goods. This indication of geographical indication, as I said, emanates from a particular area or for a particular territory which is known for a particular quality or characteristics of the goods. The object of the Geographical Indication of Goods Act is to protect the consumer from getting confused. Suppose somebody wants to purchase rice, which type of rice he wants, basmati, etc., which type of which place, etc. So those who have manufactured in that area, they get paid, they get the geographical indication of that, and therefore the consumer does not get confused as to what he is going to say. then there is no deception because the registration of such indication is already there. This specific has a specific purpose regarding origin also, geographical origin, and possesses qualities, possesses reputation that relate to that origin, and a clear link between product and the original place of production. For example, I say watches. When we refer to watches, it is international. If you refer to watches, you will say immediately Swiss watches with respect to so you will say Swiss watches. When you come to Swiss watches, then you design which particular Swiss watch you want. So clear indication will switch on. Another very interesting thing. For example, you want some painting, but if you want a painting which is in one area of India very well known, then you will always ask Madhubani painting. So Madhubani painting as such is registered under the Geographical Indication Act. Then you want some cases you want tea. In that case, tea, what tea you want? You say first of all Darjeeling tea, and under Darjeeling tea, which particular tea you want. So it is related to Darjeeling. Darjeeling, as you know, is an area in India. So first of all, you want a Darjeeling tea. And out of Darjeeling tea, which tea you want? So this is specific indication. Protection of Plants, Varieties and Farmers' Right Act. That is another act. This act gives definition of the terms of breed in relation to the variety. That is, it also provides registration of new plant varieties and their use for agricultural protection. Now, recognizing and protection of rights of farmers and facilitating the growth of seeds which they manufacture. So they have one variety of seed, after second crop, they get second variety of seed, and particular variety of seed they feel is very good for breeding. So they get it as a protection of their plant variety, they can get it registered, and therefore the profit which comes by purchase of those seeds in the market will accumulate and then will be divided between them. Or then there is semiconductor integrated circuit layout. Now this, you might be knowing nowadays, is very popular, but when it was made, this act was to provide for protection of semiconductor integrated circuits, their layout, their integrated circuit, and for matters connected therewith. Or matter, no, you have made a semiconductors, one circuit you have made, and that circuit is protected. From that circuit, many more circuits may emanate. But that particular circuit which you have specifically manufactured yourself or produced yourself or created yourself, however, that is protected under Semiconductor Integrated Circuit Layout Right. The Information Technology Act is another act which deals with authentication of electronic product, information technology. This is electronic records by the use of crypto system and hash functioning. However, I like to mention that to check the infringement and to check the brand of popular goods, consumer goods, etc., the above acts which I have mentioned are only relevant to specific items, a specific area or specific geographical area. But the Trademark Merchandise Act and the Copyright Act, amended from time to time, are used invariably, and now I would say to a great extent, for controlling the infringement and protecting the brands of popular goods, and particularly consumers and medicine goods.
Ladies and gentlemen, I'd like to mention, there is the law and there is the how to use the law practically.
Correct.
So Mr. Sipal Singh comes from a background where he knows the law and he has used the law practically to prevent infringement of trademarks and the Copyright Act. So as we go along in the podcast, we'd be able to talk to you on practical aspects that you need as business owners that you need to sort of be looking at to prevent your products from being infringed. I'll ask the next question, Mr. Sipal Singh, is if you can elaborate the Copyright and Trademark Act, the ones which are mainly used to check infringement of trademarks and protecting brands.
To know the law and then to implement that law practically, there are two little different things, and one has to understand and integrate them. Unless you are able to integrate them, you may fall into a ditch yourself while enforcing a law, because you must not only know that these are the laws, but also so within these laws, what are the ways by which you can enforce the law. So you're right, from practical purpose, when we go ahead, Pavanji, then we'll come to that also. For the time being, I'm only giving you that what is Copyright and Trademark Act for brand protection. Now, the Trademark Act was enacted in 1999 and has been amended from time to time. In the case of unregistered trademark, some protection is given to the concerned relevant trademark as a goodwill. Okay, he has produced, so he has a goodwill, some protection is given. But if it is registered, then full protection is there. Protection conferred by registration of trademark can be extended under various specific grounds mentioned in the Act. There are various grounds in the Act, under which you can have this registration of trademark conferred to you, under which specific grounds you can take action against the infringer. In the case of unregistered trademark, the right to protection can continue indefinitely if owner uses his trademark lawfully. The Copyright Act was initiated in 1957 and amended in 1999. You must know that this is the Act, Copyright Act, which is recognized in case somebody infringes the Copyright Act, then he can be penalized not only in the civil laws, but also under the criminal laws. Main penal protection, taking penal action, was first time provided under the Copyright Act. Now, this Copyright Act is applicable from the moment of the publication. Now, mainly Copyright Act is used for publication, literary work, including computer programming, and the licensing and assignment of the copy. This act is mainly meant for literary and artistic work. Artistic, literary, sculpture, etc. is meant mainly for that work. However, this act can be used also for the artistic labels, for the artistic logos, which are affixed on some consumer goods products. As the genuine logos and labels are replicated, if the genuine labels and logos are duplicated by unethical elements, then we say that the Copyright Act is attracted because of the artistic design of the logo having been countermanded by an unethical individual. So therefore, this is the main feature of Copyright Act is that it has the penal provision straightway. You can just register a penal case, you can register a case in the police station and follow it up. And people get deterrent because once it's registered in the police, the action will start. Similarly, in the case of unregistered trademark, I have told you, some protection is provided. But in the case of Copyright Act, even if it is not registered, full protection is provided. The registration is always better than the non-registered trademark. So this particular two acts, that is trademark as well as the Copyright Act, they are used for combating counterfeiting and brand infringement.
Mr. Sipal Singh, I'd like to just ask a question, because the nature of counterfeiting spans not only one geography, it can sort of go over many geographies. Sometimes it is going from one country to another country, goods manufactured in one country have an infringement in another country. So considering the global nature of counterfeiting, particularly operations of counterfeiters and unethical elements that span multiple countries, how important is international cooperation to combat this transnational problem?
I tell you, you hit the nail on the head because this is a major transnational problem. It is a major transnational problem because it dilutes the equity and profitability of any particular brand or manufacturing unit over the world. It is not necessarily in India, it is over the world. That is why it's a transnational problem. Then, secondly, the counterfeiting exposes the brand owners to additional costs also for enforcement because, all right, their brands have been counterfeited and hence they are losing the profitability, hence the equity is diluted. But over and above, in case they want to enforce action, then enforcement action also costs them. So this litigation cost also comes on their head, the manufacturer. The government also loses in terms of taxes because if the 50% of the product is counterfeited, it is not brought on the books. It is not given a proper receipt, which is admissible. So therefore, what happens is the government also loses taxes. Over and above the consumer suffers by use of duplicate products. Because consumer suffering, you know that if he uses that product, either if it is for skin, that skin may get damaged, it is not exactly to the same extent, or if you are using for some other purpose, that means you are at the risk of your own health. You're using the duplicate product. So consumer also suffers by use of duplicate products. The operation of counterfeiters, the operation of unethical elements is now inter-country. There are gangs operating. They will operate from one country to another, and the other country will take the other gang. Because counterfeiting, lot of counterfeiting is also done. I will like to name, of course, China is one of the countries where a lot of counterfeit products are produced. Now, from China to send these products, counterfeit products, to India is very easy. They may use any route. They may use the route from via Nepal. They may use any route and send this to the neighboring countries. And neighboring country would also mean that they can send to India and affect the economy as well as the equity of the manufacturers, and also hazardous to the health and stockholders, because certain people are stockholders. They keep genuine products, but their stockholder, when he is there keeping genuine, some other man is selling non-genuine, so stockholder also feels. So this is an international problem, there is no doubt, and this is, of course, a great menace as well as the international economy is concerned.
Mr. Sipal Singh, can you suggest some measures whereby international cooperation can be improved to check this menace?
Yeah. I'll tell you, this is very important, that very often the international manufacturers, which are real top-class manufacturers, they do have that cooperation, or they do have that integration with their counterparts, or they're wholesaler, or not wholesaler. Then you may say the product is brought from A place to B place. They'll say, all right, we have got so and so person who look after our interests. So therefore, there is a lot of cooperation, coordination needed. First, at the level of the people who are there, their representatives in India from abroad. Our Indian in China, our products are also counterfeited. Indian products also nowadays. So we have to have that sort of equation with other country who should look after interests. Then the other countries and the country of origin, they both should have coordination as to find out which are the agencies who possibly can take action. See, these agencies who have to take action, they should be competent enough, they have knowledge enough to undertake action against the counterfeiter. The laws prevailing in the particular country should be known, because unless you know the laws of that country, you cannot enforce. You may be knowing the laws of USA, but you may not be knowing what are laws prevailing in India. Or you may be knowing the laws in India, you may not be knowing the laws prevailing in USA. So the interconnection, they must know where you have to attack the counterfeiter, what are the laws prevailing in that country, and how that particular enforcement agency or a particular private agency can help them in using these laws. In this respect, I'll tell you another point which is very, very important as far as counterfeiting and infringement of products in India is concerned. That is, there are a provision of Indian Penal Code. When I'm coming to law, there are provision of Indian Penal Code, and these provision of Indian Penal Code also, to great extent, help in checking counterfeiting. Because we must know that we are registering a case not only under the Copyright Act or under the Merchandise Act, but we are also putting in the section of the Indian Penal Code which is being violated. Because there are provisions under the Indian Penal Code, under the substantive law, relative provisions of the Indian Penal Code can be used to put in the FIR. So therefore, I said that when this international problem is there, A, B, C, D things have to be known to the person, that what are the laws in the country, who will be able to enforce better, and whether they'll be able to do it to the extent they require, and how they can check this transnational problem. Substantive.
No, we will, when we go into the case studies in the later podcasts, ladies and gentlemen, we'll talk about the actions that we've taken sometimes in our neighboring countries, and tobacco products being shipped from one country to another. So we'll talk of these cases and they'll be of great interest to you. But now,
Yes.
Mr. Sipal Singh, I come back to the question, what are the key provisions in the Indian Penal Code, such as sections 420 and section 486, in combating counterfeiting? And how do they address intentional selling of counterfeit products?
The substantive law and relative provisions of Indian Penal Code must be known for any person who is dealing in checking or combating the counterfeiting. Indian Penal Code, there is a section 420 which deals with cheating. The cheating provisions are ipso facto applicable in terms of infringement also. Because you're cheating the consumer, you're cheating the person because he is asking you a particular product, a particular brand, a particular item of a particular known brand. Let us say he asks you, he wants oil. He asks you, I want so and so oil, parachute oil or something. And you give a parachute oil in the same bottle, same logo, and this is a duplicate one. So what are you doing? You're cheating him. So the provision of cheating comes in. In addition to brand infringement, because it is infringed the brand of a parachute oil. Instead of genuine brand, he has used that. I'll come to when he's used the logo, etc. He is also cheating as far as the particular manufacturer is concerned. But in addition to that, he's also cheating the customer. So section 420 of the Indian Penal Code is also added in addition to the Copyright Act. Then we have got section 486. That is, again, provision of Indian Penal Code. That is knowingly and intentionally selling products which are counterfeit. Now, knowingly and intentionally, the word is very important. So we have to again combine it with the Copyright Act. So he says, but you have to come with a proper evidence beforehand, you should have. That no, he knew this. He had the intention to cheat. He knew very well that this product is counterfeit. Not only because he is purchased at a cheaper rate, but also because it is a constant business of his to do such thing. And in fact, in one or two cases, I'll tell you in the case studies that we refer, in one or two cases, an interesting thing that he claimed the same thing, that I do not know. I have purchased from so-and-so manufacturer, so-and-so stockholder, this product. So there, I didn't know that it's a counterfeit product. Okay, right, you purchased. What rate? What is your receipt for that product? He produced a receipt for one or two items. But lo and behold, in his house, in the interior of that village, in his house, he was manufacturing that product himself also. So we had already information that he knows very well, and he just gets some products genuine and mixes up his own products, lot of his own products which he is counterfeited or himself produced. So with the result that is knowingly and intentionally selling these products, counterfeit products, and therefore the section 486 of the Indian Penal Code is attracted. Then you come to section 28. Section 28 again of the Indian Penal Code also has, it deals with passing of products. Pass of the product as genuine, but actually it is not a genuine product. To pass of the products by virtue of its label being good, by virtue of its wrappers being good. The labels and wrappers look alike, absolutely like the original. So therefore, section 28 is attracted. As for section 28 is attracted, I like to refer to a very interesting law case of a Sunlight and Lifebuoy soaps. In this case, he was passing off the counterfeit product to the consumer. The manufacturer or his representative or the agency which was taking action against the particular person who was passing off they went to the session court. The session court awarded conviction to this particular individual and particular counterfeiter. However, this conviction was set aside by High Court. High Court said no. Why? They said the wrappers were not the exact colorable imitation of original. The color was slightly different. So it's pink, pink was a little reddish pink. Or there were certain differences in the wrapper whereby the color was not exactly the same as by the original. The enforcing agency as well as the police authorities, because they are already registered the case and the police prosecution, they went to the Supreme Court. And Supreme Court restored the conviction awarded by the session court. On the plea, that is not a question of only culpable imitation and passing off. The very fact that any purchaser who is innocent purchaser, he just sees a life boy or he sees sunlight. He doesn't want to clarify whether it's this color and that color. Thereby, he gets deceived. It's not a question of you are trying to deceive, but you are definitely trying to deceive because your intention was that. And you say this is a different product. You are not selling the different product. If you're selling the different product, produce a different type of. Why are you having the same sort of imitation? So therefore, the passing of section of the Inner Penal Code, that is section 28, is attracted.
So I think what we've learned is that section 420, 486, and section 28 are the more important sections under the penal code, which sort of can take the infringers to the court. Now let's move on, especially onto the artistic work. How does the Copyright Act deal with infringement of artistic work?
How does the Copyright Act infringement of artistic work?
How does the Copyright Act deal with infringement of artistic work?
Yeah. Actually, Copyright Act, as I showed you, the main idea of copyright I submitted to you in the beginning was in respect of literary work, artistic work, as well as sculpture was concerned. Therefore, the Copyright Act starts with that. This is actually the infringement of artistic work. But when we take the copyright, use the Copyright Act for penal action against, we also say that the artistic work for which the copyright has been initiated is also applicable to the logos as well as for the literature produced by them. So this is one side. Actually, as I told you, basically the Copyright Act is meant for an infringement by artistic work. There's no doubt about that. That clearly says. And they say that section 51 is there of the Copyright Act, which read with section 14C of the Copyright Act. Under the Copyright Act, a case is filed on the plea that the labels or artwork which we are saying are not only a label and artwork which is violated. In this case, the section clearly says that they are violating the very concept of the copyright. The copyright is based basically for the artistic work. So for the artistic work, we immediately involve them that this is how the particular book has been duplicated. This is how the particular artistic work has been duplicated. This is how the particular sculpture has been duplicated. And therefore, the Copyright Act straightway gets attracted. It's interesting to tell you that the law lays down that when some artist, or let's say an author, wants to write a book, he gives a caption of book. Let us say you give a caption of book, infringement and so on so. And you start thinking. The very process of thinking makes you an owner of copyright. The very process of thinking, he'll prove how he had proved this label, he had written a little narrative himself, he had written a brief note himself, which is lying, and we produce it, and such year he started a book. Now the 2 years passed, this is still going on. Therefore, in this case, very interesting, very concept by an artist itself. I mean, the mental concept of an artist, he just started a text copyright. Of course, when the book is produced, or when the work of art is produced, or the works of, then certainly a text copyright if you duplicate. But even if you have not duplicated, the book has not come into it, but you have used the same narrative or same thinking which you are having in your mind, you get a copyright protection. So that is a very interesting part, that actually copyright is the basic act which is for artistic work and book rights, books, etc. Trademark Act has a statute definition of certain things, and therefore the infringement cases are invariably in trademark. Statute definition is given in section 21M, but infringement attract provision of section 134 also. And you will, so when they found that the trademark is basically as a civil law we are using, and is not attracting deterrent in the minds of the duplicator. So the lot of cases are brought before the government and before the trademark authorities. And ultimately, in the year probably 2003, some offenses of Trademark Act were made cognizable, which means they were made penal offenses, cognizable offenses. When you have a cognizable offense under the law, it is a penal action is attracted. So they were made cognizable. Without anything, you can register a case with the police authorities, but there were certain stipulation laid down. While in the Copyright Act, you can register case in the police station, irrespective of fact what is the designation of the police officer in the police station. But under the Trademark Act, the registration is done and made as a cognizable offense under section of the Trademark Act only by virtue of the fact that the police officer of the rank of Deputy Superintendent of Police is investigating the case for such a cognizable offense under trademark. The above provision of Copyright Act and then Trademark Act, read with section 91 and 93 of the Criminal Procedure Code, are followed for taking criminal action against the offender. So the difference I have given you very important. The Copyright Act makes most of the offenses, because they are literary offenses, cognizable, and therefore they are penal offenses. But from copyright, we take derivative and logos and literature. We say this is also violation of copyright and this is a cognizable one. While in the trademark, all the offenses are dealt under the civil law, except the offenses where you feel is a cognizable, where you feel it is a definitely violation. But if the offense is recognized as cognizance is taken by a deputy superintendent of police of that place. So this is there, that this stipulation is there. But anyway, cognizable offense and penal provisions have been introduced under the Trademark Act also from 2003.
That's excellent, sir. Now, let's say you were to go to a police station and say that you have a case of copyright, infringement of Copyright Act based on some artistic work. What are the arguments that you would put forward for the police to register your case?
Yes. You see, this is really a very, I should say, a little ticklish problem. It's not a question of argument. It is in the Copyright Act, the offenses are cognizable. You have only to give a FIR, or I will not talk even FIR. You have only to give the information, the general diary information in writing, that so-and-so product, let us say any product of Johnson & Johnson, P&G, HUL, whatever the main products are there, this is in en masse being stored somewhere, and that person is therefore violating the Copyright Act. He cannot store a duplicate product. And you say he is doing it. Now, according to law, this particular offense is initially preliminary investigation is done by the police authority. It is not question of DSP. Any police, because the cognizance, copyright is all, any police officer of Thana can take cognizance by your writing to it. And once he takes cognizance, yes, it is being duplicated, he writes an FIR, first information report on the basis of our general diary. And on the basis of that FIR, etc., then your question will come that what witnesses are required, because once you have written an FIR, and the court ultimately has to convict a person. Therefore, that proper investigation is important. However, this investigation, which is to be done by the police, is actually done by the person or the agency who's enforcing. The police doesn't have that much time to go and get into all nitty-gritty as what. So you, as a supplement, you are supplementing the police in investigation. That means you are telling him, this product I have purchased, here is the product you see. Then at the time of purchase also, you take you become very, very cautious that purchasing the duplicate product, you get it notarized. You take a notary there to the particular shop. And then in the presence of notary, he doesn't know, the shopkeeper doesn't know, he's a notary. We purchase 5 products or 6 products or 6 items. And the outside notary will come, seal it and say, this item was from so-and-so shop, which is notarized thing, and therefore there's nothing wrong in it. Then over and above, when the police has already taken cognizance, then we have to tell the police that product is lying at such and such place. Again, we have to give evidence that it is lying at such and such place. We have to tell him. For that purpose, we use sometimes decoy customers. That we already, our decoy customer goes and purchases more products. And sometimes we use the trade front agent. We ask a person that he wants so many products. He wants 100 bottles of shoulder, heads and shoulders. So he places a decoy customer, our decoy customer just places order with a little advance. That person brings 100 products. And then the police is informed that there are already 100 is definitely there. Over and above what is there in its stock, you have to see. So you have got collected evidence correctly. First, you have to find out where it is being stored, where it is being manufactured. Then you have given a general diary report. then you have made it into FIR by supplementing the police investigation. Then when FIR is there, then we collect further evidence, and on the basis of all this evidence, then the case is filed in the court of law for conviction. Invariably, investigation is to be done by police. The other people, their relatives or the other people are only helping the police in the process of investigation. So therefore, in the case of Copyright Act, when you're taking into action, you're going to take action against penal offenses, you must be prepared. Otherwise, either the police will not follow up the case, or you feel you may come up with a case of defamation against you, that you have filed a general diary and you have filed a wrong general diary. So therefore, the evidence has to be collected by that, either by the enforcing agency itself, that is the police and the other enforcing agency. Trademark, there are certain other enforcing agency, there are assistant commissioners, etc. of the trademark. Or if the penal action immediately you want that FIR should be filed, then at least you should be having some preliminary evidence that this has been purchased from so-and-so shop and he has got so much products to say, and the purchased product and notarized project can be deposited in the police station to prove that we are right and this man is indulging in counterfeiting.
That's excellent, sir. Now, moving on to the last part of the podcast today. In the case of literary works, particularly books, how are rights vested in writers and acquired by publishers? What challenges arise also with electronic rights? Can you give
This is a critical question, a very right question. The books, in the case of books, the rights are vested in the writer, I showed you initially, because he is the person. Or in the case of sculpture, the right to be vested with a particular sculpture. Or in the artistic world, right to be vested with the person who is painting. The initial rights are definitely, in this case of books, are vested in the writer. Now, these are acquired by the publisher. There is understanding, legal understanding, laid down sort of norm and laid down proper language for the publisher to acquire the book. I have said I have published this book, or the book is under publication, because I told you the very concept of the book means it is my book. It's a book of a writer. So I said, this is book. He knows me. He says, all right, he is a good writer. He has earlier produced this book, and this book is going to publish. He says, all right, you give me the right. So publisher acquire the rights by payment, some understanding this amount is to be paid. Up to so many books will be sold by the publisher. There are 2,000 books is authorized, and he'll pay the writer its first payment and acquires the right to sell 2,000 books. Once he has acquired the right, the publisher has only right for the free use and is called first right owner. Free use of 2,000 books or 5,000 books or whatever is written in their bond between the agreement between the writer and this is because it's a free user and is the first right owner. Yani from the author to the publisher is the first right owner of that book. Reprinting rights are covered under the second right, because if you have already given right for 2,000 books or 4,000 books, and further reprinting is required, when the book will become very popular, you want 5,000 books to be published, the other rights are sometimes vested in the printer. This is the second right. That means, all right, I have given for 4,000 or 2,000 books to the first right owner, that is the publisher. But this free use of first right, if he reprints further, are covered on the second right, whether vested in a printer or it may vest in the publisher who gets it printed. So there's a second right, the further printing of the book. There's another right for the book, which is called electronic rights. This is extremely hazardous. But the economic right, electronic right, an author will not like to give an electronic right for reason. The electronic right does not give much of credence, much of significant evidence that only 2,000 books have been sold or printed, or only 4,000 books are printed. So normally the author doesn't like to have give the electronic rights. He like to give the first right, he like to give the second right of printing, but it's come to the electronic right, invariably the author is reluctant to give the electronic publication of such books.
Mr. Sripal Singh, I'd like to thank you for a wonderful discussion today on the intellectual property rights. Ladies and gentlemen, we will be having many more podcasts on the subject of intellectual property rights. We'll be also discussing some case studies which would give you greater insights into this particular area of brand protection. And as we conclude our session today, we hope this podcast has shed light on the delicate balance that is required to understand the laws that govern the intellectual property rights. I'd like you to stay tuned on for the next sessions that we have on this subject. And I'd also like to thank our president and our speaker for today, Mr. Sipal Singh, for the insights that he has given us on this subject. Thank you very much.
Thank you. Thank you very much. Thank you.